The recording is going.
Okay,
There are no participants yet to let in.
so the one, yeah, is us. Got it.
Yep, so just us out there. It
I'll
will,
watch it.
Well,
like
this
I
is
said.
this is a barn burner of a meeting that nobody
it'll
wants to
chime at
miss.
us if somebody else joins and wants to be admitted,
Okay.
so.
Time 5 o'clock?
I got 4:59 yet,
I stood up for, 5 o'clock. Everybody ready?
done, yes.
Okay. I am calling the meeting to order at 5 p.m. We'll start with roll call. Commissioner and Chair Wendy Phillips.
Okay,
Thank you.
Commissioner and Vice Chair Kathy Brett Rucker.
Here,
Commissioner Colleen Fried is absent. Commissioner Jim Richards.
here.
Commissioner Jim Phillips.
Here.
Commissioner Scott Sorensen is not present. And Commissioner Paul Pendergrass has resigned. We will be addressing that in the regular P and Z meeting on February 8th. Moving into item 3 is approval of the agenda. Is there a motion to approve the agenda?
I make a motion to approve the agenda.
Is there a second?
I'll second.
It has been moved and seconded to approve the agenda. Is there any discussion? Hearing none, I'll call for the vote. All those in favor, say aye.
Aye.
All those opposed, say no. Agenda is approved. Approval of the minutes. In item A, it states on November 15, a motion was passed to table approval of the minutes on September 14, October 12, October 13, and from the RFP interviews. Regarding the minutes of September 14th, 2023, it is the custom of this commission that a commissioner would abstain from voting to approve minutes if they were not present at said meeting. With that in mind, voting on the September 14 minutes will eventually, for that reason, result in a tie vote. 2 affirmative votes and 2 abstaining votes because both Jim Phillips and myself were gone on September 14. And so I recommend that we defer the minutes of the September 14 meeting to the February 8 meeting. Is there a motion to defer the minutes for September 14 to the February 8 meeting?
I'll make a motion to defer.
Is there a second?
I'll second.
It is moved and seconded to defer the minutes of September 14 to the February 8 meeting. Is there any discussion? Hearing none, I'll call for the vote. All those in favor say aye.
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 All those opposed say no. Motion is passed. Minutes for September 4 meeting are deferred to the meeting on February 8. Moving to the minutes for the October 12 meeting. The minutes of October 12, 2023 have been previously distributed. And in regard to corrections, in item 2 roll call, it says absent is Commissioner Jim Richards. And then in item 3, approval of the agenda, it says motion proposed by Jim R. to approve the agenda and seconded by Paul. So I'm thinking that must have been proposed by Jim P.
Me, yeah.
And then in item 4, if you go down to the third to the last line, the line ending in requested, before we get to the hyphens with by Tuesday, August 15, if you go up 3 lines to the first word is reading, then period, and then something / revise. I think that's supposed to be, and then add / revise. Perhaps?
Yes.
Okay, so let's go ahead and change that to add.
And you're on which one, October 12th?
Yes, this is October 12th on the front page.
Okay, got that one. Okay.
Item 4.
Yes, do you see it? Right here, Trent.
Okay, thank you.
Okay. So it should be just revised, right?
No, it should be add ABD/revise. And then going to page 3. And this is just a question I have, because I know that we had stuff that she was moving forward on the agenda from the year before. And so I just want to make sure that under item 7, old business, in number 1, in the third line, halfway into the line, it says, Sunny discussed an applicant from July of 2022. And then it goes on to talk about discussions with a parent and a daughter looking at a lot split. And I know that that application went in July of 2023. So is this supposed to be
July
Sunny discussed an applicant from July of 2023?
23.
Or is it supposed to be 2022?
Believe the recording said 2022, but I believe probably it would have been 2023.
Okay, thank you.
So we'll make that 2023.
Okay. And that was it for the things that I saw that needed to be corrected. Are there any further corrections to the minutes for October 12, 2023? Is there a motion to approve the minutes for October 12, 2023?
I make a motion to approve.
With
Okay,
those 3 corrections.
with
Yeah,
those 3
three
corrections. And is there a second?
I'll second.
So Jim Phillips has made the motion. Kathy Bryant Recker has seconded the motion. It has been moved and seconded to approve the minutes as corrected for the meeting on October 12, 2023.
Jim P, right?
Is there any further discussion?
Sorry. This is-
Hearing none, I'll call for the vote. All those in favor say aye.
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 All those opposed say no. Motion is passed. Minutes of October 12, 2023 are approved as corrected. Moving on to minutes from the special meeting on Friday, October 13, 2023. These minutes have been previously distributed. And are there any corrections to the minutes? If there are no corrections, is there a motion to approve the minutes for October 13, 2023 special meeting?
I make a motion to approve.
And is there a second?
Second.
It has been moved and seconded to approve the minutes of the October 13, 2023 special meeting. Is there any discussion? Hearing none, I'll call for the vote. All those in favor say aye.
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 All those opposed say no. Motion is passed. Minutes for October 13, 2023 special meeting are approved. And then moving to the Thursday, October 12, 2023, 11 a.m. interview with WSB. These minutes were previously distributed. Are there any corrections to the minutes? Since there are no corrections, is there a motion to approve the minutes for the RFP interview with WSB?
I make a motion to approve.
Second.
It's been moved and seconded to approve the minutes of October 12 for the WSB interview. Is there any discussion? Hearing none, I'll call for the vote. All those in favor say aye.
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 All those opposed say no. Motion is passed. Minutes for the RFP interview Thursday, October 12, 2023 at 11 a.m. with WSB are approved. Moving to Thursday, October 12, 2023, 1 PM interview with SRF. These minutes have been previously distributed. Are there any corrections to the minutes? Since there are no corrections, is there a motion to approve the minutes?
Make a motion to approve the minutes for October 12th.
And there is a motion. Is there a second?
I'll second.
It's been moved and seconded to approve the minutes from the RFP interview at 1 PM on October 12th, 2023 with SRF. Is there any discussion? Hearing none, I'll call for the vote. All those in favor say aye.
Aye.
All those opposed say no. Motion is passed. Minutes for the October 12, 1 PM RFP interview with SRF are approved. And then we have Thursday, October 13, 2023, 1 PM interview with Stantec. These minutes were previously distributed. Are there any corrections to these minutes? Since there are no corrections, is there a motion to approve the minutes for October 13, 1 PM interview with Stantec?
I'll make a motion to approve.
Is there a second? So
Okay,
it's been moved and seconded to approve the Thursday, October 13, 2023, 1 PM interview with Stantec. Is there any discussion? Hearing none, I'll call for the vote. All those in favor say aye.
Aye.
All those opposed say no. Motion is passed. Minutes for the October 13, 2023, 1 PM RFP interview with Stantec are approved. And that completes the minutes for meetings. We will go ahead and move the September 14 to February 8 as previously voted. And we will move into new business, which is the WSB contract. So as I looked at this contract, the only thing that I believe that I highlighted in the 18 pages that I saw that needs to be changed is the date on the very first line of the contract, because it says blank December 2023. So as soon as this contract has gone through the approval process, then that date will be dropped into place, and I'm sure everything will be just fine with that. So let's go ahead and do this. We're going to read through this contract together, and let's just get into it. So this contract is made this blank day of December 2023, which we will be changing, by and between the City of Orinoco and Minnesota Municipal Corporation, 115 2nd Street Northwest, P.O. Box 195, Orinoco, Minnesota, 55960, which will be referred to as City, and WSB LLC, a limited liability company under the laws of the state of Minnesota, 701 Xenia Avenue South, Suite 300, Minneapolis, Minnesota, 55416, which will be referred to as the consultant moving forward. Collectively, the city and the consultant will be referred to as the parties. Whereas city requires certain professional services in conjunction, its municipal zoning ordinance review and update project. And this will be referred to as project. And whereas consultant agrees to furnish the various professional services required by city for completion of the project. Now, therefore, in consideration of the mutual covenants and promises contained herein, the parties agree as follows. Section 1, consultant services and responsibilities. A, scope of services. Consultant agrees to perform various project services as detailed in Exhibit 1. Scope of services attached hereto and incorporated herein by reference. B, changes to scope of services / additional services. Upon mutual agreement of the parties hereto pursuant to Section 6, Paragraph J of this contract, a change to the scope of services detailed in Exhibit 1 attached hereto may be authorized. In the event that such a change to the scope of services detailed in Exhibit 1 attached hereto requires additional services by consultant, consultant shall be entitled to additional compensation consistent with Section 3 of this contract. Consultant shall give notice to the city of any additional services prior to furnishing such additional services. City may request an estimate of additional cost from consultant, and upon receipt of the request, consultant shall furnish such cost estimate prior to city's authorization of the changed scope of services. C, changed conditions. If consultant determines that any services it has been directed or requested to perform by city are beyond the scope of services detailed in Exhibit 1 attached hereto, or that due to changed conditions or changes in the method or manner of administration of the project, consultant's effort required to perform its services under this contract exceeds the estimate which formed the basis for the consultant's compensation, consultant shall promptly notify city of that fact. Upon mutual agreement of the parties, hereto pursuant to Section 6, Paragraph J of this contract, additional compensation for such services and/or an extension of time for completion thereof may be authorized. In the absence of such a mutual agreement, amounts of compensation and time for completion shall be equitably adjusted, provided that consultant first provides notice to the city as required by this paragraph, and city has not terminated this contract pursuant to Section 4, Paragraph B. Standard of care. This is item D. Services provided by consultant or its subcontractors and/or subconsultants under this contract will be conducted in a manner consistent with that level of care and skill ordinarily exercised by members of consultants' profession or industry. Consultants shall be liable to the fullest extent permitted under the applicable law without limitation for any injuries, loss, or damages proximately caused by consultant's breach of this standard of care. Consultant shall put forth reasonable efforts to complete its duties in a timely manner. Consultant shall not be responsible for delays caused by factors beyond its control or that could not be reasonably foreseen at the time of execution of this contract. Consultant shall be responsible for costs, delays, or damages arising from unreasonable delays in the performance of its duties. And if you guys have any questions about any of this, just holler, okay? E, insurance. Consultant shall not commence work under this contract until consultant has obtained all insurance required herein, and such insurance has been approved by city, nor shall consultant allow any subcontractor to commence work on a subcontract until such subcontractor has obtained like insurance covering as to workers' compensation, liability, and automobile insurance. All this insurance coverage shall be maintained throughout the life of this contract. 1, consultant agrees to procure and maintain at consultant's expense statutory workers' compensation coverage. Except as provided below, consultant must provide workers' compensation insurance for all its employees. If Minnesota statute section 176.041 exempts consultant from workers' compensation insurance, or if consultant has no employees in the city, consultant must provide a written statement signed by an authorized representative indicating the qualifying exemption that excludes consultant from the Minnesota workers' compensation requirements. If during the course of the contract, consultant becomes eligible for workers' compensation, consultant must comply with the workers' compensation insurance requirements herein and provide city with a certificate of insurance. 2, consultant agrees to procure and maintain at consultant's expense commercial general liability and business automobile liability insurance coverages, insuring consultant against claims for bodily injury or death or for damage to property, including loss of use, which may arise out of operations by consultant or by any subcontractor or by any employed by any of them or by anyone whose acts any of them may be liable, including automobile use. The following coverages shall at a minimum be included in the CGL insurance: premises and operations, bodily injury and property damage, personal and advertising injury, blanket contractual liability, and products and ongoing and completed operations liability. The required automobile liability coverage must include coverage for any auto which extends coverage to owned autos, non-owned autos, and hired autos. Such insurance shall include, but not be limited to, minimum coverages and limits of liability specified in this paragraph. Or required by law. Cities shall have additional insured status and be listed by name on an endorsement attached to such policy or policies for the services provided under this contract, and shall provide that consultant's coverage shall be primary and non-contributory in the event of a loss. 3, consultant agrees to procure and maintain at consultant's expense the following insurance policies, including the minimum coverages and limits of liability specified below or as specified in the applicable insurance certificate or certificates, or as required by law, whichever is greater. Workers' compensation statutory limits, employer's liability, $1 million, general liability, $1 million per occurrence, $1 million aggregate, professional liability, $3 million per claim, $3 million annual aggregate, automobile liability, $1 million per occurrence combined, single limit for bodily injury and property damage, shall include coverage for all owned, hired, and non-owned vehicles. 4, professional, and then in parentheses, errors and omissions, close parenthesis, liability insurance. Consultant agrees to procure and maintain at consultant's expense professional/technical liability insurance. The required policy will provide coverage for all claims consultant may become legally obligated to pay to the extent caused by any actual or alleged negligent act, error, or omission related to consultant's professional services required under the contract. Consultant is required to carry the following minimal limits: $3 million per claim, $3 million annual aggregate, or as specified in the applicable insurance certificates, or as required by law, whichever is greater. Any deductible will be the sole responsibility of consultant and may not exceed $200,000 without the written approval of city. If consultant desires authority from city to have a deductible in a higher amount, consultant shall so request in writing, specifying the amount of the desired deductible. The retroactive or prior act's date of such coverage shall not be after the effective date of this contract, and consultant shall maintain such insurance for a period of at least 3 years following the completion of the work. If such insurance is discontinued, extended reporting period coverage must be obtained by consultant to fulfill this requirement. 5, true, accurate, and current certificates of insurance showing evidence of the required insurance coverages are hereby provided to city by consultant and are attached hereto as Exhibit 2. I've noticed that no insurance certificates are attached yet, and so we don't have an opportunity to review those, but as soon as this has been accepted, I'm sure all of those things will be put in place. So number 6, Any insurance limits in excess of the minimum limits specified herein above shall be available to city. 7, consultants' insurance policies and certificates shall not be canceled without at least 30 days advance written notice to the city or 10 days prior written notice to city for non-payment of premium. Consultants' policies shall be primary insurance and non-contributory to any other valid and collectible insurance available to city with respect to any claim arising out of the consultant's performance under this contract, except for consultant's professional liability insurance. Number 9, consultant is responsible for payment of contract-related insurance premiums and deductibles. If consultant is self-insured, a certificate of self-insurance must be attached. 10, consultant shall ensure that all subcontractors comply with the insurance provisions contained in this contract, and such insurance is maintained as specified. 11, consultant's policies shall include legal defense fees in addition to its liability policy limits, with the exception of the professional liability insurance and technology errors or omissions insurance, if applicable. 12, all policies listed above except professional liability insurance or other coverage not reasonably available on an occurrence basis shall be written on a per occurrence basis, in parentheses, claims made and modified occurrence forms are not acceptable, close parenthesis, and shall apply on a per project basis. 13, consultants shall obtain insurance policies from insurance companies having an AM Best rating of A-, financial size category 7 or better, and authorized to do business in the state of Minnesota or as approved by city. 14, effect of failure to provide insurance. If consultant fails to provide the specified insurance, then consultant will indemnify and hold harmless city and city's officials, agents, and employees from any loss, claim, liability, and expense, including reasonable attorney's fees and expenses of litigation, to the extent necessary to afford the same protection as would have been provided by the specified insurance. Consultant also agrees that if applicable, law limits or precludes any aspect of this indemnity, then the indemnity will be considered limited only to the extent necessary to comply with that applicable law. The stated indemnity continues until all applicable statutes of limitations have run. If a claim arises within the scope of the stated indemnity, city may require consultant to A, furnish and pay for a surety bond satisfactory to city, guaranteeing performance of the indemnity obligation, or B, furnish a written acceptance of tender of defense and indemnity from consultant's insurance company. Consultant will take the action required by the city within 15 days of receiving notice from city. Notwithstanding the foregoing, city reserves the right to immediately terminate this contract if consultant is not in compliance with the insurance requirements contained herein and retains all rights to pursue any legal remedies against consultant. Section 2, city's responsibilities. A, city shall promptly compensate consultant as services are performed to the satisfaction of the city's administrator in accordance with Section 3 of this contract. B, city shall provide access to any and all previously acquired information relevant to the scope of services detailed in Exhibit 1, attached hereto, in its custody to consultant for its use at consultant's request. C, city will, to the fullest extent possible, grant access to and make all provisions for entry upon both public and private property as necessary for consultant's performance of the services detailed in Exhibit 1 attached hereto. D, The city administrator shall serve as the liaison person to act as city's representative with respect to services to be rendered under this contract. Said representative shall have the authority to transmit instructions, receive information, interpret and define city's policies with respect to the project and consultant services. Such person shall be the primary contact person between city and consultant with respect to the services from consultant under this contract. City reserves the right to substitute the authorized contract person at any time and shall notice consultant thereof. Section 3, consideration. A, fees. City will compensate consultant as detailed in Exhibit 3, compensation, which is attached hereto and incorporated herein by reference for consultants. I get the page turned. For consultants' performance of services under this contract. If city fails to make it, B, if city fails to make any payment due consultant for services performed to the satisfaction of the city's administrator, expenses within 30 days after the date of consultant's invoice, consultant may, after giving 7 days written notice to city and without waiving any claim or right against city and without incurring liability whatsoever to city, suspend services and withhold project deliverables due under this contract until consultant has been paid in full all amounts due for services, expenses, and charges. Section 4, term and termination. A, term. This contract shall be in effect until such time as the project is completed or otherwise provided in this contract, or as otherwise provided in this contract, whichever comes first. B, termination. Notwithstanding the foregoing, this contract may be terminated by either party for any reason or for convenience by either party upon 7 written notice. I think we need to have a days in there, don't we?
Yes.
In the event of termination, city shall be obligated to consultant for payment of amounts due and owing, including payment for services performed or furnished to the date and time of termination, computed in accordance with Section 3 of this contract. C, default. If consultant fails to satisfy any of the provisions of this contract or so fails to perform and or administer the services detailed in Exhibit 1 hereto attached, or attached hereto, pursuant to the requirements of Section 1 of this contract, in such a manner as to endanger the performance of the contract or the services provided hereunder, this shall constitute default. Unless consultant's default is excused by city, city may, upon written notice, immediately cancel this contract or exercise any other rights or remedies available to city under this contract or law. D, suspension of work. If any work performed by consultant is abandoned or suspended in whole or in part by city, consultant shall be paid for any services performed to the satisfaction of the city's administrator prior to consultant's receipt of written notice from city of such abandonment or suspension, but in no event shall the total of city's payments to consultant under this contract be required to exceed a percentage of the total contract price calculated by either the contract price or the maximum price set forth in Exhibit 3 attached hereto, equivalent to the percentage of the scope of services completed by consultant to the satisfaction of the city's administrator as determined by city. Section 5, indemnification. A, consultant shall indemnify and hold harmless city and its respective officers, directors, employees, and members from and against claims, liability, damages, costs, judgments, or expenses, including reasonable attorney fees, to the extent caused by the negligent or otherwise wrongful acts or omissions, including breach of a specific contractual duty of consultant or consultants, independent contractors, subcontractors, agents, employees, vendors, or delegates with respect to this contract or the project. Consultants shall defend city against the foregoing or litigation in connection with the foregoing at consultant's expense with counsel reasonably acceptable to city, except that for professional liability claims, consultants shall have no upfront duty to defend city, but shall reimburse defense costs to city to the same extent of consultant's indemnity obligation herein upon adjudication by a court of competent jurisdiction and only to the extent attributable to consultant's negligence. City, at its expense, shall have the right to participate in the defense of any claims or litigation and shall have the right to approve any settlement which approval shall not be reasonably withheld. The indemnification provision of this section shall not apply to damages or other losses proximately caused by or resulting from the negligence or willful misconduct of city. All indemnification obligations shall survive termination, expiration, or cancellation of this contract. Consultant agrees that in order to protect itself and city under the indemnity provisions set forth above, it will at all times during the term of this contract keep in force policies of insurances required in the paragraph entitled Insurance. Nothing in this contract shall be construed to waive any immunities or limitations to which city is entitled under Minnesota statute, chapter 466, or otherwise. B, cities shall indemnify, protect, save, and hold harmless consultant and its respective officers, directors, employers, and members and agents from and against any claims, liability, damages, costs, judgments, or expenses, including reasonable attorney's fees, to the extent attributable to or caused by the negligent or otherwise wrongful acts or omissions of city or its agents, employees, contractors, or subcontractors with respect to city's performance of its obligations under this contract. City shall defend consultant against the foregoing or litigation in connection with the foregoing at city's expense. Consultant at its expense shall have the right to participate in the defense of any claims or litigation. The indemnification provision of this section shall not apply to damages or other losses proximately caused by or resulting from the negligence or willful misconduct of consultant. All indemnification obligations shall survive termination, expiration, or cancellation of this contract. C, nothing contained in this contract shall create a contractual relationship with or a cause of action in favor of a third party against city or consultant. Consultant services under this contract are being performed solely for the city's benefit, and no other entity shall have any claim against consultant because of this contract or the performance or non-performance of services provided hereunder. Section 6, general terms. Voluntary and knowing action. The parties, by executing this contract, state that they have carefully read this contract and understand fully the contents hereof, that in executing this contract, they voluntarily accept all terms described in this contract without duress, coercion, undue influence, or otherwise, and that they intend to be legally bound hereby. B, authorized signatories. The parties each represent and warrant to the other, one, the persons signing this contract are authorized signatories for the entities represented, and two, no further approvals, actions, or ratifications are needed for the full enforceability of this contract against it. Each party indemnifies and holds the other harmless against any breach of the foregoing representation and warranty. C, notices. All notices and other communications required or permitted under this contract shall be in writing and hand-delivered or sent by registered or certified mail, return receipt requested, postage paid or postage prepaid, or by overnight delivery service, and shall be effective upon receipt at the following addresses, or as either party shall have notified the other party. The parties' representatives for notification for all purposes are City Renee Wild, Deputy City Clerk, 115 Second Street Northwest, P.O. Box 195, Orinoco, Minnesota 55960. Phone number 507-367-4405. Email rwile@orinoco.com. Consultant is Lori Johnson, Senior Professional Community Planner, WSB LLC, 701 Xenia Avenue South, Suite 300, Minneapolis, Minnesota, 55416. Phone number 612-364-3029. Email address ljohnson@wsbeng.com. D, dispute resolution. City and consultant agree to negotiate all disputes between them in good faith for a period of 30 days from the date of notice of dispute prior to proceeding to formal dispute resolution or exercising their rights under law. E, electronic digital data. Because of the potential instability of electronic/digital data and susceptibility to unauthorized changes, copies of documents that may be relied upon by city are limited to the printed copies, also known as hard copies, that are signed or sealed by consultant. Except for electronic digital data, which is specifically identified as a project deliverable by this contract, or except as otherwise explicitly provided in this contract, all electronic digital data developed by consultant as part of the project is acknowledged to be an internal working document for consultants' purposes solely, and any such information provided to city shall be on an as-is basis strictly for the convenience of city without any warranties of any kind. In the event of any conflict between a hard copy document and an electronic digital data, the hard copy document governs. The electronic digital data shall be prepared in the current software in use by consultant and is not warranted to be compatible with other systems or software. Independent contractor status, item F. Consultant at all times and for all purposes hereunder shall be an independent contractor and is not an employee of the city for any purpose. No statement contained in this contract shall be construed so as to find consultant to be an employee of city, and consultant shall not be entitled to any rights, privileges, or benefits of employees of city, including but not limited to workers' compensation, health/dental benefits, and indemnification for third-party personal injury/property damage claims. Consultant acknowledges that no withholding or deduction for state or federal income taxes, FICA, FUTA, or otherwise will be made from the payments due consultant, and that it is consultant's sole obligation to comply with the applicable provisions of all federal and state tax laws. Consultants shall at all times be free to exercise initiative, judgment, and discretion as to how to best perform or provide services identified herein. Consultant is responsible for hiring sufficient workers to perform the services / duties required by this contract, withholding their taxes and paying all their employment tax obligations on their behalf. G, acceptance of deliverables. Each deliverable shall be subject to a verification of acceptability by city to ensure such deliverable satisfies stated requirements. The acceptability of any deliverable will be based on city's satisfaction or non-satisfaction with the deliverable based on requirements of this contract. If any deliverable is not acceptable, city will notify consultant specifying reasons in reasonable detail, and consultant will, at no additional cost, conform the deliverable to stated requirements of this contract. H, subcontracting. Consultant shall not enter into any subcontract for performance of any services contemplated under this contract without the prior written approval of city. Consultant shall be responsible for the performance of all subcontractors and or subconsultants. As required by Minnesota statute 471.425, consultant must pay all subcontractors less any retainage within 10 calendar days of consultant's receipt of payment from city for undisputed services provided by the subcontractor, and must pay interest at the rate of 1 1/2% per month of any part of a month to the subcontractor, or any disputed amount not paid on time to the subcontractor. I, assignment. This contract may not be assigned by either party without the written consent of the other party. J, modification / amendment. Any alterations, variations, modifications, amendments, or waivers of the provisions of this contract shall only be valid when they have been reduced to writing and signed by authorized representative of city and consultant. I think I'm okay.
You
Thanks.
want someone else to read for a little bit?
Yeah, you want to read for a while, please?
Yes.
Oh my, thank you.
I will start, so top of page 10,
Yes.
letter K, records - availability and retention. Pursuant to Minnesota statute 16C.05 subdivision 5, consultant agrees that city, the state auditor, or any of their duly authorized representatives at any time during normal business hours and as often as they may reasonably deem necessary, shall have access to and the right to examine, audit, excerpt, and transcribe any books, documents, papers, records, etc., which are pertinent to the accounting practices and procedures of consultant and involve transactions relating to this contract. Consultant agrees to maintain these records for a period of 6 years from the date of termination of this contract. L, force majeure. The parties shall each be excused from performance under this contract well and to the extent that either of them are unable to perform for any cause beyond its reasonable control. Such causes shall include but not be restricted to fire, storm, flood, earthquake, explosion, war, total or partial failure of transportation or delivery facilities, raw materials or supplies, interruption of utilities or power, and any act of government or military authority. In the event either party is rendered unable, wholly or in part by force majeure, to carry out its obligations under this contract, then the party affected by force majeure shall give written notice with explanation to the other party immediately. M, compliance with laws. Consultant shall abide by all federal, state, and local laws, statutes, ordinances, rules, and regulations now in effect or hereinafter adopted pertaining to this contract or to the facilities, programs, and staff for which consultant is responsible. N, covenant against contingent fee. Consultant warrants that it has not employed or retained any company or person other than a bona fide employee working solely for consultant to solicit or secure this contract, and that it has not paid or agreed to pay any company or person other than a bona fide employer any fee, commission, percentage, brokerage fee, gift, or any other consideration contingent upon or resulting from award or making of this contract. O, covenant against vendor interest. Consultant warns that it is not employed by any vendor of equipment or service provider that could result in a commission, percentage, brokerage, or contingent fee as a result of consultant's association with city. P, non-discrimination. The provisions of any applicable law or ordinance relating to civil rights and discriminations shall be considered part of this contract as if fully set forth herein. Q, interest by city officials. No elected official, officer, or employee of city shall during his or her tenure or employment and for 1 year thereafter have any interest, direct or indirect, in this contract or the proceeds thereof. R, work product. All materials such as reports, exhibits, models, graphics, computer files, maps, charts, and supporting documentation produced under work authorized by this contract, parentheses, materials, on parentheses, shall become the property of city upon completion of the work and payment in full for services performed. City may use the information for the project for which they were prepared. Such use by city shall not relieve any liability on the part of consultant, notwithstanding any of the foregoing to the contrary. A, consultant may reuse standard details of its materials in the normal course of its business, and B, city understands that the materials have been prepared for a specific project and are not intended to be reused for other purposes. If city reuses the materials for any other purpose or modifies them without consultant's consent, city waives any claims against consultant arising from such reuse or modification and agrees to defend and indemnify consultant from any claims arising from such reuse. S, governing law. The contract shall be deemed to have been made and accepted in Olmsted County, Minnesota, and the laws of the state of Minnesota shall govern any interpretations or constructions of the contract without regard to its choice of law or conflict of law's principles. T, data practices. The parties acknowledge that this contract is subject to the requirements of Minnesota's Government Data Practices Act, in parentheses, Act, on parentheses, Minnesota statutes, section 1301, example, consultant agrees to abide by the applicable provisions of the Act, HIPAA requirements, and all other applicable state or federal rules, regulations, or orders pertaining to privacy or confidentiality. Consultant understands that all of the data created, collected, received, stored, used, maintained, or disseminated by consultant in performing those functions that the city would perform is subject to the requirements of the Act, and consultant must comply with those requirements as if it were a government entity. This does not create a duty on the part of consultant to provide the public with access to public data if the public data is available from the city, except as required by the terms of this contract. U, no waiver. Any party's failure in any one or more instances to insist upon strict performance of any of the terms and conditions of this contract or to exercise any right herein conferred shall not be construed as a waiver or relinquishment of that right or of that party's right to assert or rely upon the terms and conditions of this contract. Any express waiver of a term of this contract shall not be binding and effective unless made in writing and properly executed by the waiving party. V, data disclosure. Under Minnesota statute 270C.65 subdivision 3 and other applicable law, consultant consents to disclosure of its social security number, federal employer tax identification number, and/or Minnesota tax identification number already provided to city, to federal and state agencies and state personnel involved in the payment of city obligations. These identification numbers may be used in the enforcement of federal and state laws, which could result in action requiring consultant to file state tax returns, pay delinquent state tax liabilities, if any, or pay other city liabilities. W, patented devices, materials, and processes. If this contract requires or consultant desires the use of any design, device, material, or process covered by letters, patent, or copyright, trademark, or trade name, consultant shall provide for such use by suitable legal agreement with the patentee or owner, and a copy of said agreement shall be filed with city. If no such agreement is made or filed as noted, consultant shall indemnify and hold harmless city from any and all claims for infringement by reason of the use of any such patented, designed device, material, or process, or any trademark or trade name or copyright in connection with the services agreed to be performed under the contract, and shall indemnify and defend city for any costs, liability, expenses, and attorney's fees that result from any such infringement. X, mechanics liens. Consultant hereby covenants and agrees that consultant will not permit or allow any mechanics or materialmen's liens to be placed on city's interest in the property that is subject of the project during the term hereof. Notwithstanding the previous sentence, however, in the event of any such lien shall be so placed on city's interest, consultant shall take all steps necessary to see that it is removed within 30 days of its being filed, provided, however, that consultant may contest any such lien, provided consultant first posts a surety bond in favor of and insuring city in an amount equal to 125% of the amount of any such lien. Letter Y, severability. The invalidity or unenforceability of any provision of this contract shall not affect the validity or enforceability of any other provision. Any invalid or unenforceable provision shall be deemed severed from this contract to the extent of its invalidity or unenforceability, and this contract shall be construed and enforced as if the contract did not contain that particular provision to the extent of its invalidity or unenforceability. Z, entire contract. These terms and conditions constitute the entire contract between the parties regarding the subject matter hereof. All discussions and negotiations are deemed merged in this contract. Section AA, headings and captions. Headings and captions contained in this contract are for convenience only and are not intended to alter any of the provisions of this contract and shall not be used for the interpretation of the validity of the contract or any provision hereof. Section BB, survivability. All covenants, indemnities, guarantees, releases, representations, and warranties by any party or parties, and any undischarged obligations of city and consultant arising prior to the expiration of this contract, parentheses, whether by completion or earlier termination, parentheses, shall survive such expiration. Section CC, execution. This contract may be executed simultaneously in two or more counterparts that, when taken together, shall be deemed an original and constitute one and the same document. The signature of any party to the counterpart shall be deemed a signature to the contract and may be appended to any other counterpart. Facsimile and email transmissions of executed signature pages shall be deemed as originals and sufficient to bind the executing party. And it says remainder of this page intentionally left blank. We are now on section Roman numeral 7, signatures. And it's the signing block and witness whereof the parties shall hereunto executed this document the day and year first above written. So referring back to the original date. There is a section block for WSB to sign for Kim Lindquist, I guess.
Lindquist.
And then City of Orinoco, we have a section block that has a spot for Ryland, Ida Horst, its mayor, and Renee Wild, its deputy city clerk. We do have several exhibits. I don't know if you want to read through.
No, these.
We are good with where we're at.
Yeah, and so let me explain though that exhibit 1, I spoke with Lori and I asked her if she would pull from the original proposal that they submitted and put in the description of the scope of services and to also put in a description of the timeline for the execution of the schedule. Then if you look at Exhibit 2, that's gonna be where all of the insurance certificates are going to be attached. Exhibit 3 is compensation. Would you like to read that, or do you want me to go ahead and read that one?
Go for it.
Okay. So on page 16, Exhibit 3, compensation. Subject to the limitations set forth in this exhibit, city will compensate consultant in accordance with the rate schedule below for the time spent in performance of services under this contract, provided that under no circumstances shall consultants' total charges to city, including expenses, exceed $63,252, maximum price in parentheses. Unless such charges in excess of the maximum price are authorized in writing by the city administrator, they are incurred by city. City will make periodic payment to consultant upon billing at intervals not more often than monthly at the rate specified in the schedule of fees included herein, provided that no bill/invoice submitted to city shall exceed a percentage of the maximum price equivalent to the percentage of the scope of services completed by consultant to the satisfaction of the city administrator as determined by city. Rate schedule follows on next page. And this is the rate schedule, once again, that was in the original submission proposal. And then on the final page, this was the breakdown of the hours that were going to be required for all of the different elements in the project regarding scope of work.
So, let me ask. Was the two of you that went through the original contract?
I went through the original contract.
So,
I believe that Kathy did as well.
Yeah.
so thank you
And-
guys for doing that.
And I called Lori and I asked her if she would be willing to add those charts that were in here that described very specifically the scope of work, the dollar amounts for the different people in their firm that would be executing the work, and the amount of money that each of those people would be paid for those services. The actual timeline that says from the starting date, this is how many weeks this will take, this is how many weeks this will take. And Lori and I agreed that, you know, we'd already passed the original start date for this. And so by the time that we got this contract approved, we were going to determine a new start date, and that would move that timetable completely.
Mhm.
And so it was a call to her. I made a request for her to add those things to the contract, and they did that within a couple of days' time. She's very responsive.
Well, thank you
You're
for
so
doing all
welcome.
that. That's a lot. Thank you, Kathy.
We hit that first one line by line when it came through. just
We
to make
did.
Sure.
Yeah, we sat at my kitchen table, right?
And had quite a few different suggestions for the attorney to take a look at and or add or
Mhm.
update, just to make sure that one, that it's fair for both sides and that we're both covered. You know,
Equally.
contracts are great. You hope everything goes right, and most of what's here is for things that don't go right. And you hope you never have to execute most of this.
Mhm.
Well, thank you guys.
You're so
As a
welcome.
planning and zoning commissioner and a city council person, I appreciate what you guys have done. There's a lot here.
Yeah, there is.
You are quite welcome.
All the way from the RFP, starting from that, writing that, and getting all this put together to where it is, and the interviews that we all took place in to be able to come to this conclusion.
I'm excited for the real work to begin though on this.
Yeah.
And-
Well, and one
Well,
of the things that was
yeah.
exciting for me is that what we got to see and experience is how we work as a team.
Right.
And that has been very satisfying. Now, we have a bit of business left here, and that is there a motion to approve the WSB contract with that those two recommended changes, the first one being the date on the first page, and the second one being the addition of a word that was omitted
Page 6.
on page 6. Thank you.
So I'll make a motion that we approve the contract with the revisions that were just stated.
I second, want to second it?
No, go ahead, go ahead.
I'll second it.
Okay, so it's been moved and seconded to approve the WSB contract with the recommended changes. Is there any discussion? Hearing none, I'll call for the vote. All those in favor of approving the WSB contract with recommended changes, please signify by saying aye.
Aye.
All those opposed, please say no. The WSB contract with the recommended changes is approved, and thank you all very much. Now, this is just the reminder. Orinoco Planning and Zoning is an advisory commission, and we will be forwarding our recommendation to the city council for their consideration at their next regular meeting. And do you know the date of that meeting right off the top of your head, Guy?
I don't have it.
I know that our next one is February 8th, I believe.
So it's the Tuesday, the 12th, I think, isn't it? Or
Okay,
13th,
so
I'm sorry.
that, which one? Which time?
So it's gonna be down below this.
It's gonna be a
third-
Tuesday, right?
Tuesday,
third
February,
Oh, yeah, yeah, yeah.
Tuesday, February
13th, yeah, I'm
13th.
sorry. I'm in-
Okay, so
I think the third.
Or
It's the,
it's,
it could be that we might have some special meetings in between too. that
okay,
we
well,
might be
whatever
able
the
to-
next,
whatever the
whatever the next
schedule-
city council meeting is, then it will be decided at that meeting, because city council is the final authority in these matters. So with that being completed, I believe we have no unfinished business or other business on this agenda. And so is there a motion to adjourn?
I'm gonna make a motion to adjourn.
Second?
Second.
It has been moved and seconded to adjourn. All those in favor say aye.
Aye.
All those opposed say no. Meeting is adjourned at 6:06 PM.